Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? All you beautiful people here joining me for another live on a Sunday night. I don't know if we've ever done one on a Sunday night. It's a long weekend. Work starts on Tuesday. Tomorrow is a holiday. Happy 4th of July for all of the Americans here. And hopefully you guys have some fun plans for tomorrow and for this weekend. Before we get back to it, there's some fireworks going on in the background. I don't know if you guys can hear them, but I can hear them. So people are starting early in my neighborhood, I guess, or a neighborhood nearby, because they're seeming loud and they sound like gunshots. But today we're here to talk about Johnny Depp and Amber Heard yet again. When more things happen and you all send it to me and you guys put the bat signal out that you want to hear a breakdown of this, then I'm going to do it. I mean, that's basically how we run this channel. That's how we pick our content. The more people that are interested, the more likely we're going to do a breakdown. So today we are going to go over their motion to set aside the verdict, but also they filed it as a motion to dismiss the complaint as well, which I thought was very interesting. And sure, you can do that, but you don't have to call it a motion to dismiss at this point. We're going to start out by reading the first paragraph of this. I'm not going to read the whole 53 pages. So if you're here for me to read the whole 53 pages, I apologize. It ain't going to happen. I'm not going to be here for 5 hours reading this entire thing. What we are going to do is we are going to read the initial paragraph just because I have some comments on it. We are going to read the summary, which gives you an idea of what the full motion says. And then I'm going to go into some more detail and pick out some of the things that I think are some of the more interesting arguments that Amber Heard's lawyers made throughout this motion. And we're going to break them down, talk about whether they're legitimate, whether they're not. We're going to break down certain parts more than others. But without further ado, let's take a look at this first paragraph. So it is the defendant and counterclaim plaintiff, Amber Heard's post-trial motions. The defendant and the counterclaim plaintiff, Amber Laura Heard, hereby moves this court to set aside the jury verdict on all three counts of plaintiff and counterclaim defendant John C. Depp's complaint, to dismiss the complaint and to investigate potential improper juror service. So we're going to get to each part, but this is them asking to dismiss the complaint, knowing that they're going to lose. This is what it looks like when a lawyer does something, even though they know they're going to lose, because they think it's procedurally appropriate. Hold on one second. Okay, so they know they're not going to win this part. Okay, they know they're not going to win it. They put it in here. This is what it looks like. Lawyers do this stuff all the time. File things that they know they're not going to win. It is not improper. It is not anything they're going to get sanctioned for. It is not anything the judge is going to hold them in contempt for. Although somebody did send me a transcript of a hearing where the judge said, Ms. Brederhoff, I don't want to have to do this, but you're accusing the other side of doing things that are improper when in fact you continue to do things in an improper way. And I have to admonish you, telling you that's not the way we do it. So I'm sorry that I have to say this, but you need to shape up and stop calling out the other side, telling them to shape up, which is very interesting to me. Okay, let's jump down to the summary here, which I think is really interesting. And it gives you kind of an entire picture of what they're arguing throughout the 53 pages. And this is, you're starting to see kind of what appellate motions will look like. They have put all the page numbers in, all the case law, made all the arguments, the table of authorities, all these cases that they cite throughout the entire motion. But we're going to read just a couple pages here together, and then we're going to dive deeper into the other stuff. But what we're going to read together is just this. Defendant and counterclaim plaintiff Amber Heard respectively moves this court to set aside the jury's verdict on all three counts of plaintiff and counterclaim defendant Depp Depp's complaint, dismiss the complaint, alternatively to order a new trial and to investigate potential improper juror service. In support, she relies on the record, including objections, arguments during the hearings and at trial, motions to limit, motion to strike. So that's all normal. And we saw Johnny Depp's lawyers file something similar to that in attachment to the judgment. So, summary of the argument. From the beginning, Mr. Depp set out to try this case as a domestic relations dispute he wished he had tried rather than settled in 2016. Mr. Depp's counsel argued throughout the trial that the issues before the jury began 6 years ago, when Ms. Heard obtained a domestic violence temporary restraining order against Mr. Depp on May 27, 2016. Mr. Depp and his legal team told the jury that they were seeking to restore Mr. Depp's reputation, his legacy for his children, that this was the first time Mr. Depp had been able to tell his story since Ms. Heard obtained the DVTRO in 2016. This is what I was saying from the jump. This seems like a domestic violence case. This seems like a criminal case. We said that from the jump. And we asked, why are Amber Heard's lawyers allowing this? Yet, that's what this trial felt like the entire time. And if they made these arguments the entire time and the judge allowed all this argument in that was improper, that I talked about being improper and outside the scope, then maybe they have a good argument for appeal. However, they took the bait. They took the bait. They made arguments on the DV side. They slung the mud. They made it a character assassination going both ways. And they made this argument as much about domestic relations as Johnny Depp's team did. So the problem is, if you were going to, like I said, if you were going to stick to the simple defense that this was true, you talk about the one or two times that actually makes sense with the pictures, you ignore the mudslinging, you stick to the statements, you stick to the defamation, then I think you might actually have an argument here. But the way that Amber Heard and her team tried this case, I think blows this argument. I do not think they have a chance with this argument. The claims in this case were far different than the case Mr. Depp tried to the jury and Ms. Heard. That's the problem. It's not just the case Mr. Depp tried to the jury, but also that Ms. Heard tried to the jury. Mr. Depp's claims arose from an op-ed published in the Washington Post on December 18th, 2018. 2.5 years later, Mr. Depp alleged that 3 statements, one the title authored by the Washington Post, formed the basis of his defamation claims. To avoid explaining to the jury the UK final judgment finding Mr. Depp to have committed 12 acts of domestic violence, including sexual violence, Defendant Exhibit 133, Mr. Depp represented to the court he would limit his damages claims to the period of December 18th through December 18th of 2018 to November 2nd of 2020, the date of the UK judgment. Yet Mr. Depp made no such effort at any point in the trial to so limit his claim damages. Instead, throughout even the closings, Mr. Depp continued to urge the jury to restore his reputation and legacy to his children as a result of Ms. Heard accusing Mr. Depp in May of 2016 of domestic violence and obtaining a DVTRO. So this is really important because if Mr. Depp is the one that limited the damages, and he did so in order to keep the UK judgment out and the UK verdict out and the facts of the UK case out, this is a good argument from Amber Heard's team because Mr. Depp did nothing to limit the timeline of the damages to that time period outside of put it in the jury instructions. So it's very interesting to me. It's interesting that Mr. Depp is the one that limited the time period because I didn't know that because I didn't read the pretrial motions. I just listened to what came out in the trial, and you couldn't really tell who limited it. But neither side, in my opinion, did a good job of limiting the so people are saying the UK trial was against the Sun, not Amber Heard. But it sounds like the judge may have allowed the UK judgment to come in, but for Johnny Depp saying no, just give me 1 second. I'm almost done going through this. But for Johnny Depp saying no, I will limit the damages to outside that UK judgment. in order to make that UK judgment irrelevant in this case. So this is very interesting to me. The jury's verdict was obviously influenced by Mr. Depp's pleas in the face of the court's preclusion of Ms. Heard from introducing evidence that Mr. Depp had already, in fact, been adjudicated in the court of his choosing to have committed not just one act of domestic abuse, all that was needed in this case for a defense verdict, but 12 acts of domestic violence, including SV. The exclusion of the UK judgment, coupled with Mr. Depp's continuous urging to the jury to go back 6 years and exonerate him and restore his reputation, resulted in an indefensible $10 million compensatory damage verdict and $5 million punitive damage verdict. The verdict is excessive as a matter of law in light of the evidence and law and should be set aside. Further evidencing the confusion resulting from Mr. Depp's efforts to relitigate the 2016 domestic relations matter without the truth of the UK judgment, the jury's dueling verdicts are inconsistent and irreconcilable. We'll talk about that. The finding of defamation against Ms. Heard with a $2 million award is inconsistent with the finding of defamation against Mr. Depp with a $15 million award. In the face of these inconsistent verdicts, the judgment should be set aside and a new trial ordered. At trial, Mr. Depp proceeded solely on a defamation by implication theory, abandoning any claims that Ms. Heard's statements were actually false. But whereas here, the statements are true on their face, which Mr. Depp never challenged. Disagree with that. The plaintiff is a public figure, which Mr. Depp has conceded he is, and the subject matter of the op-ed is on matters of public concern, which the court earlier determined as a matter of law. The First Amendment prohibits claims by implication. While this appears to be a case of first impression in Virginia, case of first impression means they haven't really settled what was happening in the law, which way this should go. Dicta in our courts and holdings in other courts in similar circumstances warrant applying this doctrine to this case, setting aside the judgment and dismissing the complaint. Mr. Depp never challenged the fact that Ms. Heard did not write the title of the op-ed. Not true. One of the three defamatory statements comprising Mr. Depp's defamation claims. Instead, Mr. Depp contended Ms. Heard's tweet of the link to the article the following day constituted actionable republication, in addition to establishing dangerous precedent, suggesting anyone tweeting or retweeting an article or link can be independently liable for the content. This interpretation is beyond the reach of Virginia law on republication, except for the fact that she's retweeting something that she wrote and that she did and had a hand in. Because nothing in Ms. Heard's tweet constituted a legally enforceable republication, this count should be dismissed. Since the damages award does not separate out the three separate statements, in the event the court does not dismiss all three counts, the judgment should be set aside and a new trial ordered on the remaining counts. They may not be wrong on this if the judge does throw out one of the counts and dismiss one of the counts, because the way the verdict form was set up, it wasn't split up as to which count equaled which amount of money. For the jury to find Ms. Heard demonstrated actual malice, Mr. Depp was required to establish at the time of the op-ed was published, Ms. Heard did not believe that she had been abused or that she had doubts about whether she was abused. But Mr. Depp presented no evidence that Ms. Heard did not believe she was abused. Instead, the evidence overwhelmingly supported that Ms. Heard believed she was the victim of abuse at the hands of Mr. Depp. Therefore, Mr. Depp did not meet the legal requirements of actual malice and the verdict should be set aside. This is just hogwash. They could have made this argument, and they didn't. They presented a very different story of a mountain, of a monster of evidence. That is the problem. And in my opinion, the way that they argued this case, Amber Heard was able to tell her story. Johnny Depp absolutely called it a lie. And they're saying he never said that she lied. He absolutely did. The lawyers themselves called her a liar. And they found her story to not be credible. So there was evidence that she lied. There was evidence to contradict that she was an abuse victim. There was evidence that she didn't believe she was an abuse victim because the jury didn't believe her stories. That's the problem. Next, Mr. Depp improperly relied on time-barred and judicially privileged statements as the basis for his defamation by innuendo claims. Although actionable innuendo must be drawn from the four corners of the document in this case, it could only be drawn from the reference in the article to Ms. Heard obtaining a DVTRO against Mr. Depp in 2016. This warrants setting aside the verdict on all three defamation counts. Finally, this is the last paragraph. The information on the jury panel list, did you hear me? This is the last paragraph. Finally, the information on the jury panel list appears to be inconsistent with the identity and demographics of one of the jurors, juror number 15. And this is where we'll spend a lot of time. Juror number 15 was apparently born in 1970, not 1945, as reported to and relied upon by the parties in this case, including Ms. Heard, in selecting a jury panel. Given the requirements for verification of each juror, it appears the identity of the juror was not verified. It is unclear if juror number 15 was in fact ever summoned for jury duty or qualified to serve on the panel. This warrants an investigation by the court to determine if the juror was in fact summoned and whether the due process rights of the parties were bypassed. Depending on the results of the investigation, this may justify setting aside the verdict entirely. Okay. So you can take this now. Thank you. So that's the end of the summary of the argument. So when we get to each one of these arguments and we dig in a little bit more, okay? Because, again, I'm not going to read 53 pages on here. I don't think it's necessary. When we get into their summary of their argument, this is how I look at it. The best arguments they have are that Johnny Depp improperly argued damages that he agreed he wouldn't argue. This is the first time they're giving context to that UK judgment and verdict not coming in and the timeline of the damages. Because before, when they just said, oh, you can't argue these damages because he already tried to argue them in the UK trial, that's true. But if Johnny Depp, in fact, agreed that he wasn't going to argue these damages, and then they did, and they allowed these gray areas to come in, they may have an argument. I still don't think they win, in case you're not picking up that vibe. I don't think these are winning arguments, but I think they are more than just grasping at straws. Because when you look at things that you agree to do pre-trial, and then you break those agreements during the trial, that is usually a reason for an appeal. But the judge during the trial, if that was really what was agreed to, would have cut Johnny Depp's arguments off and not allowed him to argue those damages. So that may have been the reason that the damages arguments were kind of vague throughout the trial. The damages arguments were not pinpointed to specific dates. It was more like the stuff going on with Amber, the conversations, the litigation. Litigation is bad for you. And the other thing is, Amber Heard's team kind of cured a lot of these arguments by talking about the UK trial, right? If I'm an appellate court and I'm looking at this, I mean, definitely one of the interesting things about this motion that I'm sure you already know because other lawyers have already talked about this motion, but one of the interesting things is Judge A is the one that's going to be making this decision. So basically she would have to admit now or agree now that she made a bunch of mistakes throughout the trial. And throughout the trial, she shouldn't have let him make these arguments. She did let him make these arguments, but now we have to do this 6-week trial all over again and waste everybody's time and money. So that's the first thing. That's the first hurdle to get over, to where there's about 0% chance they win anything. But I do think there could be something that results from this, and we'll get to that a little bit later. But when talking about the damages, the UK verdict, Amber Heard's team over and over and over again made arguments about that UK trial. They let the jury know that there was a UK trial, that Johnny Depp already got to make these arguments, that Johnny Depp already got to tell these stories, that Johnny Depp already got to call these witnesses. They made that argument very clear to the jury. So I think, again, Amber Heard's team would have had a better argument if they had a different trial strategy. And they would not have brought up the UK trial, objected to the timeline of damages, and now made this argument that they argued these damages they shouldn't have been able to argue. But because the Google people talking about, well, when was the UK trial Googled? When did he file that UK complaint? When did his Q score go down? When did he lose these contracts? They made more of those arguments than Johnny Depp's team did. So to me, they kind of blew up their best chance at an appeal by how they tried the case. All right, so let's get into some of these points a little deeper. And then I'll dive deeper where you guys have more questions. So let me know what questions you have specifically about this motion, how it's going to affect things in the future, because I'll spend a lot of time answering questions, as I always do. Damages not supported by evidence, and the damages were excessive. $15 million basically is way too much, and therefore we need a new trial. Not even close. They were asking for $50 million. They put $50 million on the board. He lost 20-something million from Pirates. There's a good argument that $10 million was some kind of a compromise verdict from the jury, not excessive. We talked about this. I said if they would have given him $300 billion, then that would have been excessive, and then potentially the judge could have limited those damages. Again, throughout, I agree some of the damages arguments were weak, but at the end of the day, they presented enough for the jury to come up with a number that they came up with. If they want to say that they throw out one of the statements and they can't split up how much money was for each count, then fine, that's a good argument. But I don't think they're going to win that. They again then talk about the drunk, drugs, late, all these other reasons that he could have lost these jobs or been damaged, but those are fact questions that they already argued to the jury that the jury didn't buy, that the jury came down on. He lost $10 million in compensatory damages because of Amber Heard, because of this defamation, because of these lies. Clearly. And throughout this motion, if you all have read the whole motion, you'll see that they make these same factual arguments they made to the jury that the jury didn't buy. This is not the time for the judge to disagree with the jury based on a fact question when the jury is the fact finder. That's not going to happen here. All right, inconsistent verdicts, okay? The next point that they make. We talked about this, and I said, I think these verdicts are inconsistent. I do. I think they're inconsistent. And I took it as Amber Heard should lose because of that. Johnny Depp's team should appeal. I think they should win the appeal because these are inconsistent verdicts. But then, after further examination and questions from you guys, and could this be consistent? Is there a way we could look at it and make an argument that they actually are consistent? And I think there actually is. I think that they could believe that Amber Heard lied and defamed Johnny Depp in the op-ed. But they can also believe, as we've discussed in other videos, that Amber Heard's friends were not involved in setting up a hoax and roughing the place up and calling law enforcement multiple times. So I do think that that there is an argument that these verdicts could be consistent. But one of the good things they did in this, Amber Heard's team, is quote Johnny Depp's lawyers, saying this is a very interesting complaint. These are mirror images of each other as far as claims goes. It's an all or nothing argument. And I agree with that. And I said that multiple times. This is all or nothing. We either believe Johnny or believe Amber. But I stand corrected by this jury. I think they actually could have found that it wasn't a hoax set up by Amber's friends. And just because it's an inconsistent verdict doesn't mean it has to be overturned. Because Amber could lose on appeal, or Johnny, I should say, could win on appeal, and they could throw out and overturn Amber's verdict, which could make it more consistent. But at the end of the day, a verdict like this, whether it's inconsistent, whether it's consistent, we don't know because we are not in the minds of the jury. If the jury comes out and speaks, that may give us more evidence as to what they did, which is already something that we're seeing happen in other cases, which is why I always say maybe the jury should just wait till all the appeals are done, just write a book or something. But if the jury came out and said something that's obviously wrong that they misunderstood, then that would add fuel to this fire about it being an inconsistent verdict. However, what's more likely is an appellate court thinking this is a compromise verdict of some sort. And there's nothing unlawful or illegal about a compromise verdict. The jury did not just disregard something. Maybe they felt, like, yeah, she lied and hurt Johnny and we need to punish her. But, Johnny also hurt her a little bit by his lawyer saying it was a hoax when we don't really believe that her friends had anything to do with the hoax. And I don't think a court's going to overturn that based on a compromise verdict that we know happens a lot. The next 3 points I'm going to kind of take in combination. That truth is an absolute defense to defamation. Defamation by implication is improper. No evidence of actual malice. A lot of argument that Johnny's a public figure. These were all legal arguments that they made to the judge that they made in other motions that the judge just denied and did not agree with. So instead of diving in and spending hours on this portion, which some people think is a really good argument, okay, I've heard people say, "Oh, wow, absolute truth. This was absolute truth." I think the jury absolutely felt it was false. I think the jury absolutely called this out as not believing what Amber Heard said. So in order for this to be absolute, just because Johnny Depp is a public figure, just because she, maybe they don't believe that she felt the wrath, but just because he is a powerful male figure or a rich male figure does not make what she said absolutely true. Just because there were true facts in that op-ed does not mean it can't be defamation and that she wasn't lying about the important stuff that I think Johnny's team proved to the jury that she was lying. So I don't find these arguments to be credible. I think there is a 0% chance Judge A grants it at this point. When they file their appellate brief, if we want to look at it more in depth, then that's fine. If it may have some viability at that point, that's fine. I think it has a 0% chance of being successful at this point. We don't need to rehash the title, in my opinion. We don't need to rehash the republication. There was a jury instruction on it about how they can consider the tweet. They considered that. They looked at the facts. They looked at the evidence. They looked at the jury instruction. They found that it was her words and it was defamation. They made some more arguments about how it wasn't about Johnny Depp. It was about this bigger picture, about a cultural issue that needed to be fixed and needed to be changed. That's fine. Cultural issue. It is important. It needs to be changed. But that's not what the statements were that were defamation. The statements were that she suffered this abuse at the hands of her partner or whoever 2 years ago, which was clearly Johnny Depp. That she felt Johnny Depp's wrath. That's the part that he sued on. That's the part the jury didn't believe. So these arguments are conflated and trying to mix issues and create gray areas where gray areas don't exist, in my opinion. It was fleshed out. So then they, even when talking about actual malice, say it means that Heard had to believe that she wasn't abused. In order to prove actual malice, they have to prove that Heard believed she wasn't abused. And again, I hate to rehash the argument I kept thinking they were going to make, which was a simple defense that in her mind, the constitutionally protected opinion that when he grabbed her and moved her to the side and she got that bruise on her arm, when he headbutted her, which he admitted and he said was on accident, she believed in her opinion that it was on purpose. That should have been their argument. And then they would have had a much better argument here for actual malice, that she believed she was abused. But instead, she explained all this stuff where the pictures did not match it. She basically said, believe this is my left hand, when everybody in the jury was looking and saying, that's clearly your right hand, with the pictures and other evidence. And at the end of the day, they just did not believe her. They didn't believe that she was abused. They didn't believe that she believed she was abused. They believed she was doing this to hurt Johnny Depp. And they believed it so much that they wanted to punish her to the tune of $5 million. Like that's what's interesting about this verdict, that $5 million. That tells you what the jury actually thought and what the jury actually believed. All right, juror number 15 issues. And this is very interesting to me. And this is where I believe Amber Heard's team could get what they could at least argue as a win in the public. Juror number 15, apparently on the jury questionnaire or somewhere where they confirm the identities of the jury, it says they were born in 1945. Well, in fact, they checked public records and that's clearly false and they were born in 1970. So there are some initial arguments you can make, like how does this matter? Why does age matter? You can't strike a juror for age. That's a constitutionally protected class. That would actually be actionable and sanctionable if you say, well, I would have struck that juror if I knew they were old, or if I knew they were young, or because they're a male or a female or whatever, you can't strike jurors for that reason. So their age in and of itself does not make a difference, number one. Number two, they looked at the juror, they saw the juror. I think you can probably, I mean, some people age better than others, but you can probably tell the difference of somebody that's born in 1945 and somebody that's born in 1970. So to me, they're not going to make that argument, and they don't. So instead, they argue that this juror is either a plant or was improperly summoned or came when the summons was actually for somebody else. Why is this important? Well, it's either a clerical error and juror number 15 is the correct juror and they just typed the birth date wrong. If that's the case, water under the bridge, this does not matter. But my son's name, we call him Maverick, that's his middle name, but his name is actually George Tragos. So if a jury summons came to my house and it was George Tragos with my dad's social security number and my dad's date of birth, and my son, who obviously can't show up to jury duty because he's 6, shows up to jury duty, gets picked for the jury, and it was actually supposed to be my dad, well, that could be a problem. That could be a problem because the wrong person showed up who was not in that jury pool and got picked for the jury. Now, the next part of that would then be, is that reversible error? Is that a denial of due process? And for my dad and Maverick, it wouldn't be, I don't think. They live in the same jurisdiction. They both could get called to the same jury summons, assuming my son was of age. They asked juror number 15 the questions. They picked him for the jury. Both sides were okay with him on the jury, or her on the jury. I think we know juror number 15 is a male, but with him on the jury. So that I don't think would be reversible error. That would not be a denial of due process. But if they were from 2 different jurisdictions, and my son could never serve as a juror in the jurisdiction where my dad is and vice versa, and that happened, now it could be a denial of due process because it's supposed to be a jury of your peers from your jurisdiction. So that could create an issue. Or if just the wrong person showed up with the wrong name and it's just a different person altogether, again, questions would have to be asked. So in my opinion, I think, because at the end, Amber's team basically asks, hey, judge, can you bring this juror in, ask questions, see if it was a typo, see if it was an honest mistake, see if it was a plant. And I think the judge should do that. I think the judge should further investigate. Similar to the Glenn Maxwell case, they brought in that juror, they asked him more questions. They got to the bottom of it, and the judge felt like in that case, which I thought was much worse because the juror, I don't know if we want to say lied, but some severe misrepresentations on their jury questionnaire. I think in this case, the judge, maybe not bring them in person, but ask them for certain information or try to figure it out through the court system, because I guess they have a court system where they call and verify that it's actually the right juror. So in my opinion, I do think there should be some further investigation into what this error was. I don't think we can just assume it's a father-son, it's the same name, it's the same address. I don't think we can just assume things like that. I really don't. So I think that it's important to figure out exactly what happened. And you guys let me know if you agree or disagree with that. Think about if it was your case or your son or your daughter's case, and the wrong person shows up and gets picked for the jury. So DC Babo says, what is a plant in this context? That would mean Johnny Depp's team intercepted this summons, put on somebody that was strong for Johnny Depp, who pretended like they were going to be, on this jury, that they got this summons, claim mistake later. make sure they get on that jury, make sure that they rule in favor of Johnny Depp. That would be a plant. I don't know if you've ever seen like Runaway Jury, or I think that's the one with, I think it's Gene Hackman, but I'm not even positive, where they did stuff like that. All right. So, all in all, percent chances I think she's successful in setting aside this verdict or dismissing this complaint are 0. I literally think there's no chance she wins at this stage. But I do think that this is kind of an indication of what the appeal is going to look like. And I do think they may have some legitimate arguments on appeal. Maybe some of the evidence should have come in, but does it rise to the level of overturning the verdict? It's going to be very interesting to me how this all turns out and how quickly this gets denied, in my opinion. Oh, the last thing I want to touch on, because I did get some questions about why Johnny Depp had to pay $38,000 to the ACLU. I have not read that ruling or order or whatever it is, but I promise you, I shouldn't promise you because I haven't read the order. I would be shocked if Johnny Depp had to pay any of their legal fees, any of their attorney's fees at all for fighting the subpoenas and the discovery requests. You almost never, I have never seen somebody have to pay for the fees for that. Now, if there were costs, hard costs associated with the ACLU for producing the documents or finding things or having to create them or whatever, then that $38,000 I would bet are just costs. And it cost the ACLU $38,000, and that's why John Depp had to pay. That's normal. We have to pay for copies that we get. If we subpoena something from a hospital and they send it, we have to pay for those copies. We have to pay for those records. That is totally normal, in my opinion. And if they had to pay employees or spend time gathering documents, putting stuff together, mailing it out, first-class priority mail, whatever it is, in my opinion, that's proper for Johnny Depp to have to pay that. I don't know how it got to $38,000. That's kind of crazy to me. But I would be shocked if he had to pay any of the attorney's fees that they paid fighting the subpoenas and trying to not have to turn this stuff over. I would be very, very surprised. All right, let's get to some questions. Melanie Casio. Actually, before we get to the questions real quick, Melanie, I will answer that. I don't even know if I did an intro to this video. We just kind of jumped into it. Thanks, everybody, for joining me. We're talking more Johnny Depp and Amber Heard. We're about to get to the Q&A portion of the video, which is my favorite part of the video. Subscribe to our channel if you haven't already. We are going to have some more Crumbly parent updates. There's some things going on in that case. We're going to have a Balwani verdict video whenever that comes down. We're continuing to follow the Marilyn Manson case. We've got some stuff coming up probably 2 weeks from now that we're going to do another video kind of talking about the response that people have had. Also, the Johnny Depp v. Brooks case. We're going to talk about Johnny Depp's response. So we've got a lot of things cooking. And always let me know what content you guys want to see, because that's really where I pick most of my videos and dive most of my time into. Follow us on Instagram and Twitter here at Trago's Law. We're on our way to 10K on Instagram. We've passed that on Twitter already. A ton of comments and messages that we talk through and engage on there, and it's a lot of fun. A ton of you sent me this motion on Twitter and on Instagram. So, that's always fun to talk on there and to engage on there as well. All right, now let's get to some questions. Melanie. Could they get a new trial over this juror? It'd be as ridiculous as Cosby getting off. I know there are laws/rules in place to protect us, but come on. Thanks for coming on, Uhtred. Destiny is all. Yeah, they could. If it turns out that this person should not have been in the jury pool and they showed up and ended up on the jury, it could be a denial of due process for Amber Heard. And they could actually have to overturn this, which would be insane. But there are so many things that would have to happen in order for us to get there. It actually has to matter that this is the wrong juror. Not like They sent one juror to courtroom 3 and one juror to courtroom 2, and it easily could have been flipped. They picked this juror. They all agreed to it. To me, that's more likely to be the case, but it is possible for them to overturn this verdict based on this jury, yes. Devin, what's up, man? Jury instruction covered the requirement for republication. Yes. And there were plenty of arguments made to the jury and plenty of arguments already made to the judge. And the judge clearly made their decision, and so did the jury. And appellate courts do not like to overturn this stuff unless they feel like they have to. Mo, AH wasn't supposed to mention Aquaman, but she did. Okay, I didn't see that in the pretrial agreements. I mean, it was very clearly mentioned multiple times, but that's not totally unusual. It's me, Josie. Is this something JD's team gets to respond to? Yes, they can respond to this if they want to. Yes. They can also file their own motion to set aside the verdict for Amber Heard if they want. April Wright, I feel like this will never end. Can't she move on? I know a lot of people are going to hate on her for this stuff. I'm not going to hate on her for doing what is within her rights when she lost, filing an appeal, filing these motions. Fine. To me, this is more acceptable than her media interview was. My opinion. Just one man's opinion. Temp. What happens if before the appeal is granted, AU finds Amber, I think it's Australia, finds Amber guilty, and what is UK accepts request for appeal? Can damages amount be changed instead of a retrial? No, the damages amount is not going to be changed without a retrial. The judge isn't going to just say, oh, here's the new damages amount. But if she gets convicted of perjury in another case, that can come in the next trial. If the UK verdict gets appealed and changed, that's going to change this trial completely, which is really interesting, having all of these things floating around there at once. The UK potential appeal, the Australia potential perjury, the UK potential perjury, the US appeal. A lot of stuff going on right now in this Depp v. Heard world. Barbara Kangas, if this happens to go back to trial, can JD's team show the close-up of Amber's Rocky reading her answer during the trial? Rocky clearly reading her answer during the trial? I'm not sure what this is asking specifically, but yes, if there's a new trial, they can take different angles. They can make different arguments based on evidence. They can see things they didn't see before and use them in this trial. Absolutely. Red Canary, can AH appeal above this court if they lose? Yes. Could they be making these arguments to prepare for a higher appeal? Absolutely. How does that process work? Thank you. So yeah, the first set of post-trial motions goes to the trial court judge, which is Judge Ascarati. Then it goes up to the appellate court. And then only certain cases can then go up to a higher court. One step at a time. Tracy Fagan, don't you have to show ID? Yes. That's the interesting part. I need more information about juror number 15. I need more information. I need to know how all of this happened. The reason I used my dad and my son as an example is because that makes sense to me. If my son showed up and showed his ID and they checked it off real quick, and we're like, okay, that makes sense. Wrong birth date by a lot of years. Maybe they didn't notice. I can understand that. I don't think it's like a different person or a fake ID or things like that. I would be shocked if it's something like that. Devin's Law, or if Maverick wasn't registered as a juror. Correct. If he's not if he just is not even supposed to be in the jury pool, that could be a problem. But if it did happen to be someone else, what would it matter in the big picture? If that person was not qualified or shouldn't have been a juror, shouldn't have been in the jury pool, then it could be a denial of due process. If it's just they got swapped and ended up in different courtrooms and he got juror number 1346 and he was juror number 1347 and they were in the wrong courtrooms, I don't think that would matter, because that's not guaranteed to you in due process that you're going to have specifically Peter Tragos be in your jury room. It's just, guys, think about it. We have cases all the time where we get a jury there, and then the case gets continued or something happens, a mistrial. We get a whole new set of jurors. So as long as it's someone that's registered to be a juror in that jurisdiction, then I don't think it's going to be something that overturns this case. Julie Ann Nielsen. Why specifically this juror 15? He spoke out? No, this is the juror that they found a problem or a discrepancy with. My guess is there were no issues with all the other jurors. Cordoba 82. In Fairfax County, you have to prove that you are who the summons say you are, and also you don't know what trial you're going to be assigned to. Correct. And that's one of the things that they argue in the motion. There was either a problem with the confirmation of identity issue, and they say that that alone is enough for a denial of due process. I disagree with that. I don't think that alone is a denial of due process. If this person is a potential juror in this jurisdiction, I don't think it's reversible error personally, but I would be ticked if it was my case. I'm just going to tell you that right now. If this was my case and this mess up happened, I'd be ticked. MJG, any consequences to the juror for lying if deliberately caught? Yes. If they lied, then it could be perjury. They could lie under oath potentially. They could be held in contempt. They could be fined. They could be fined for having to do this trial all over again. They could be sued by Amber Heard's team because this lie cost her all this time and money. Or even Johnny Depp's team for having to do this all over again. Toots. Could it be Amber telling her lawyers to do anything at all to try to appeal, etc.? It could be. And lawyers don't actually feel great about doing any of it. It's possible, but if you feel like you're doing something that's unethical or frivolous or that has no legal merit, you should not do that. You could be sanctioned, held in contempt, disciplined by the bar, by your local bar, by your state bar, so you don't want to do stuff like that as a lawyer. Beverly LM. If AH can't pay now, how can she pay the next trial? And AH needs to be careful because the next jury might give JD $50 million. I agree with you. There's no guarantee she's going to win the next time, especially with all this stuff out there that I think there's even more impeachable stuff for her now. However, how can she pay? None of us actually know how much money she has. We can look it up and it can say negative however many $1 million on celebritynetworth.com. Some people say her homeowner's insurance or some other insurance is paying for it. We don't know. Point is, somehow she got lawyers to represent her last time. It seems like they're still representing her. She's going to have appellate lawyers. Somehow she would find a way, my guess is, to have these lawyers, have some lawyer represent her on a second trial. Wayne Lang, our first member, thank you for the super sticker. And now's a good time to remind everybody, if you want to join our membership, we're doing some fun members-only stuff over the last couple weeks we have, and we're going to continue to. In the video description, there's the join link, so you can join there if you'd like. Thanks, Wayne. Amelia J. Does this mean that juror number 15 should find legal representation? Maybe Amber suspected he was the juror that stared down at her during trial. I think he did say on, was it GMA? I can't remember now. I've seen so many news shows that it made him uncomfortable when she was looking them in the eye, things like that. I think he is the juror that came out and made some statements, but I'm not positive. If they think he did something wrong, or if he thinks he did something wrong, yes, he needs legal representation. But if it was a clerical error and they called and said, "Are you Peter Tragos?" and I said, "Yes," but they thought it was my dead grandpa who has the same name, that's not my fault. I didn't do anything wrong. They called and asked me if it was me, and I said yes. If I just didn't look at the form I signed because it was the wrong birth date, I mean, I don't think that's going to be a criminal issue, but never hurts to have a lawyer on your side. Esmeralda Balderrama. Thank you for doing this live. We appreciate you and your time. AH won't stop and won't stop until she believes in her own head that she has won something. Thank you, Esmeralda. Yeah, it's fun. It's fun to do kind of random ones late Sunday night, especially with the day off tomorrow for most of us. Daisy Lemus, FYI, if you become a U.S. citizen, some people, like from Burma, they can create a birth date for U.S. documentation for U.S. ID. Interesting. So maybe this person just put a older birth date, but they found public records to show that the birth date's actually 1970. So that's interesting. Julia Colela Carver, thank you so much for the super sticker. Winter Walker, oh no, can she get this out of the Supreme Court? No, never going to happen. Mary Leabrook is our first new member of the video. Thank you, Mary. Azam is here. I'm sick at home. That stinks. Lawyer you know is all the remedy I need. Question number 1. You talk about trial lawyers a lot. Are there lawyers that don't do trials? What's the difference between them? Great question, Azam. Great question. You can tell you're smart, even though you don't know a lot about the legal world, especially in America. The way you think about things is exactly how you should think about them. So my dad's a trial lawyer, right? You guys all know that already. I grew up around him and at his firm, seeing him try cases. You watch the movies and you see people on TV and they're in the courtroom and they're arguing to a judge and a jury, pounding their hand on the table. They're the bulldogs, right? Those are the trial lawyers, the litigators. when I was going to law school, I couldn't understand why anybody would go through all this and all this school to not be a trial lawyer. But not only are there lawyers who don't try cases, meaning argue a case in front of a judge or a jury, there are certain lawyers who just write contracts or are in-house counsel for certain companies who are dealing with their HR manuals and internal disputes. And if they need a lawyer to litigate a case or try a case, they go outside and hire somebody and bring them in. There are lawyers that just write wills. There are lawyers that do all sorts of things that are not in court, are not in front of a judge or a jury. Absolutely, a ton of lawyers. But even in addition to that, there are tons of people that go to law school and never even want to be a lawyer. They get their Juris Doctorate degree and they go into finance, they go into banking, they go into business management to be a CEO, a CFO, a CLO. So there are all sorts of different routes you can take being a lawyer and going to law school. Great question. Question number 2, if there is a new trial, can Amber Heard win? Sure, she could win. I think the odds are stacked against her, but I think it's possible she wins. Temp, do you think Andy's elevator picks will be in the appeal? No. I don't think anything outside of the record of this case and this trial will be in the appeal. If there's a new trial, I think they'll be in that. Daisy Lemus, this is fact due to not having official documents in Burma who look Asian. I learned this in verifiable for employment on legal I-9 doc for hire. Okay. Melanie, what, if anything, do you think would have happened if this was a bench trial? I think Johnny Depp might have lost if it was a bench trial. I don't know. I think I would have guessed everybody loses if it's a bench trial. That she doesn't find that any of this is defamation if she is the finder of fact. But that's a total guess, just a total guess. That would be my guess. But I don't know. Maybe she was sitting in that courtroom. Maybe she didn't believe anything Amber Heard was saying either. And if so, I do not think with almost absolute certainty that we would have gotten the same verdict we got here. Obviously, we wouldn't have gotten $5 million in punitives because she knows the cap. But I don't think both of them would have gotten money. I don't. Veronica Hendrickson is also a new member. Tara Jensen said, I tried to join the membership. The link won't work. If you're on your phone or iPad, you have to actually go onto the website like www.youtube.com on Safari or Google Chrome or whatever it is, and then go to the page there. It doesn't work on the actual YouTube app. Other people have told me. Christina Matarang, thank you for the super sticker. I see some people following on Instagram and Twitter, which is always fun. If you're not already, at Tragos Law here is how you follow us on Instagram and Twitter. Temp, can JD add to suit an appeal like AH lawyers defame? No, you can't add to the lawsuit. You can't add to the complaint. You can't add new defamation counts. You can't add things she said in interviews. You can't add things her lawyers say. You can't do anything like that in the appeal. It's just what happened in the trial. Z. Martin, is there any weight in that AH's team accepted and agreed to this juror? Absolutely. There's huge weight into that. Would be interesting to know when her team found this problem. Thanks for the great program. That's a good question too. The judge will ask them, could you have found this earlier? Should you have found this earlier? All the research you did on these jurors and you didn't find this, because we do a lot of research on the jurors before a jury trial. If the court allows us to, some do, some don't. Federal, you can't. So that absolutely is important. And that's why I keep saying, if this person could have been on her jury on another day, then it's not reversible error because they agreed to pick this juror. So if it's a clerical error or if it's somebody else in the jurisdiction that flipped courtrooms or whatever, if there was some kind of mistake that doesn't matter, this is not going to make any difference. They may do an investigation and figure out what happened, but this is not going to change this case. But if it's me going and sitting as a juror in New York because I'm a plant for Johnny Depp, sure. If I lied my way onto the jury, sure. I don't think we have that here, but I'm open to see what actually happens in the future. But yes, this is a great question. The fact that they agreed to this juror, because we have to accept the panel as lawyers. The judge says, do you accept this panel, Johnny Depp's lawyers? Yes. Defense, do you accept this panel? Yes. That means you accept juror number 15. Great question. Joe Gottman, have you ever thought about doing criminal law? I would say criminal law, I did criminal law a lot more earlier in my career as we were building up our PI practice, because a lot of you know it's what my dad does. So I would get some of his cast-off cases when I first became a lawyer. My first 20 cases were criminal cases as I was signing PI cases as well. But now I don't think I have a single criminal case at the moment. Once in a while I have a DUI or a white-collar crime. I had like a grand theft case from somebody that was a banker. So I've had a couple cases like that. I don't do a ton of it. I like representing injured victims a lot more. I love representing people that are in times where they just feel lost and don't know what to do and feel like they're David against Goliath against a big insurance company or a big company that's a defendant. I love representing them. I feel so much more, so satisfied in that. Now, there are some criminal defendants as well that I feel the same way about. But on a larger scale, I really love what I do. I like to focus in and try to become an expert. When I go to those Florida Justice Association's conferences, it's all continuing legal education focused on that. That's where I do almost all of my continuing ed stuff. So I really like to focus on injury cases, catastrophic injury, wrongful death cases. That's really where I focus most of my time and energy. So I like to have a specialty. I don't want to practice 20 different areas of law. That's why if you guys ask me about another kind of case, I try to find somebody for you. And a lot of you get very annoyed at the delay when I'm waiting on somebody else to respond, but give a little grace because it's not a case I would take. If it's a car accident case or wrongful death case and you email me, I'll get back to you as quick as I can because I will know the answer. But if it's a family law case or a contracts case or something else, then it's more difficult because I don't handle that area. Temp. In a retrial, can the sides add claims to the suits? So they can't add new causes of action if they are outside the statute of limitations. So I will say that. But they can add new pictures and new evidence and things like that. Spirit traveler, a jury of your peers and jurisdiction. Do they have to be age and from where you live? If not, can you please explain? They do not have to be your age and they do not have to be exactly where you live. So everywhere does it a little bit different, right? But here, if you have a case in Pinellas County, people have to be pulled from Pinellas County, and they have to have a driver's license or an ID card to where they can actually pull them from the system. It can't just be a 6-year-old like my son. He can't show up to be a juror. Somebody who lives in New York and has never been here before can't be pulled down to be a juror on my case. So the jurisdiction is kind of what builds your peers. And then your peers is a much more difficult thing to define because the jury is supposed to kind of mirror you and the people around you, right? But a lot of times it doesn't happen. And I'm not going to get on my soapbox. We've done this a million times about, how there's not enough diversity in jurors. And what's the reason for that? Is because they get struck? Is it because they don't show up? Is it because, what are all the reasons for that? And that's why I give speeches literally on why it's important to show up for jury duty. Because if it was your case, would you want a person exactly like you to show up? And if the answer is yes, then when you don't show up, you could be hurting somebody that's exactly like you with your life experience, whatever, that you could understand where they're coming from. And instead, all these other people that don't understand you or where you're coming from are going to be making the decision in your life. But again, that's probably for another video. Beverly Alford. Hey, Peter, does the fact that the jury handed down awards to both Heard and Depp work in JD's favor and potential appeal? I don't think it really matters. I mean, I definitely think, so if I'm trying to make it matter, I would say if this was a runaway jury and these numbers were so excessive, 10 million and 5 million, if they're really so excessive, then why would they give Amber Heard $2 million? If the jury disregarded the evidence and went against the law and just gave Johnny Depp this humongous verdict, why did they also give Amber Heard $2 million? You know, it would have been an even higher verdict for Johnny Depp, 0 for Amber Heard. So you can try to use that type of argument, but I don't think it really matters for the appeal that they gave each side money, unless, of course, they say it was an inconsistent verdict and you need to have a new trial. Mickey Jameson Fielden. How many states can you practice law in? Well, you can be barred in as many states as you want, but you can also do what's called pro hoc vice, meaning go into one state and try a specific case or handle a specific case. You can also associate with a lawyer in other cases and handle cases. So we have cases all over the United States and all sorts of different states that we handle in different capacities. but I'm only barred in Florida. Our firm has lawyers barred in Florida and Washington, D.C. at this point, and a bunch of different federal courts all over. JL Seether, how is it determined whether it will be a bench trial or a jury trial? Thanks. So in most jurisdictions, if you ask for a jury trial, you get it. If both sides agree to a bench trial, that's how you have a bench trial. So the parties get to choose whether it's a bench trial or a jury trial. But if one party says jury trial, one party says bench trial, most jurisdictions say you're doing a jury trial because it's your constitutional right. Laura is a new member. Welcome to the clan, Laura. Jade Silverhill, do you think Elaine should have some else lead the trial? She seemed inexperienced. I've worked for lawyers for over 35 years. So from all accounts and purposes, she's very, very experienced. And a lot of people say she's got a good reputation in the area. So I don't think Elaine is going to put anybody else leading this team, but Amber Heard could hire somebody else or want somebody else to lead the team at trial if there is a retrial. My guess is somebody else will be doing this appeal, but I could be wrong. Elaine may be able to do appellate stuff too, and maybe she'll appeal this case for Amber Heard. She knows the case. Peggy Wolf, welcome to the either jury or the gallery. I think those are what our member options are. Don Studley, I've heard AH is writing a tell-all book about her marriage to Johnny Depp. Can this be the basis for another defamation trial? Potentially, yes, it could be. If she lies in it, provably lies, does it with actual malice, and damages him, and he loses money, reputational harm, all the things we heard argued in this case. It is possible, yes. She better have a different defamation expert check it out. Brianna, this trial did more or less turn into a celebrity punching match. I agree. And that's the problem, in my opinion. Lisa, isn't that what alternates are for? Yes, but not at this point, right? It's a little too late because we've already gotten the verdict that came down. Interesting. So Galoric and a couple other people said she seems like more of a legal writer than a trial lawyer. So does that mean you like her legal briefs better, like the one we read today? Azam, thank you, Peter. If there is a new televised trial, would you do lawyer react and recap on it? It depends on the trial, and it depends on if all of you want me to. And that's really what it comes down to. If you guys are interested in it, then I'll do some breakdowns of it, and I will react and do all that good stuff. All right, so a couple more minutes here of questions. So get your questions in if you haven't already. But I appreciate you all joining me again on this random Sunday night live. I appreciate all of you still talking this Johnny Depp Amber Heard case with me. I appreciate you sending me stuff on Instagram and Twitter at Tragos Law if you haven't, and subscribing and joining the membership and everything you do to support the channel. That is what makes this fun. That is why I do it. If you all went away, then the channel would go away, obviously. So you all are the best, and I appreciate you joining me in here. We're going to do about 5 more minutes of questions. And then we will bounce for the night, but we will be back on Tuesday. Yes, the golf trip is over. Saw somebody ask that. God forbid another trial. I agree. People are ripping on Elaine a little bit for the trial work. Bulletproof clipboard. Thank you. I know you will. See if we got Uncivil Law was surprisingly impressed by, I think he means by this motion. Yeah, I mean, I definitely think some of the arguments that were rehashed, Kurt, I didn't go through a ton, but I think some of it was really interesting, and some of it could lead the judge to do more things, and I think it's better as a little bit of a preview of what we're going to see for the appeal. I don't think they're going to win any of this because I think they've already made all of these arguments to Judge A. Do you think that Amber Heard is a narcissist? Beverly LM asked. Apparently, some of Johnny Depp's experts do. I am not a mental health expert or a psychologist or psychiatrist, so I don't know. Temp, thank you, Peter. You are awesome. Thank you, bud. Really, Temp, you're welcome. And thank you. Thank you for being here. Debbie, just not going to read those kind of comments, Debbie. She's cheering for a certain football team that we don't recognize here. So, Joni, a lot of people ask me this. Do we have any recorded trials? So when I worked for the prosecutor and some of the criminal trials are captured on CCTV, they're not recorded and then broadcast. They're only able to be watched if you have that CCTV channel. And then all of my PI cases, none of my clients would want them televised. It's their personal medical information coming out, a lot of family stuff coming out. Some of their tax returns come out if they have lost wages. So a lot of that stuff is private and they wouldn't want that broadcast. So it's unlikely that any would be actually televised and broadcast because there's a lot of privacy issues and rights going on. As you saw in the Johnny Depp trial, a lot of that stuff came out that they probably wanted to keep private. So, all right. After watching this high-profile case along with all the evidence that has come out since the verdict, how would any judge listen to this nonsense? Well, they're going to be looking at it objectively and legally and applying the law to the facts and making their decision based on that. I mean, that's really what they're going to do. They don't really care what anybody else is saying. I promise you that. These judges really don't care. Sparrow and C, team golf emoji. Yes, I haven't seen that nearly enough around on other channels. You got to hit that up more. That golf emoji is the best. Joe Gottman, when in law school, do they show you all videos of different cases and your teacher asks you questions? No, they don't show us actual trials. Maybe we'll go and watch a trial live. A lot of us, that are on mock trial team or moot court teams or things like that, we get a lot of that experience. We have coaches that coach us on how to do it. So we get a lot of experience that way, but we don't usually watch a trial like video like this. But maybe they will start. I mean, I probably would, if I was a professor, use videos like this to explain the do's and don'ts of cross-examination, of opening statements, of closing arguments, and things like that. I have some books that I've read, people's full closing arguments that I like. I've read transcripts of closing arguments to kind of get ideas and pull from and pair it from and what worked and what didn't work. So, and again, I use this trial that way too. It's a great refresher on the rules of evidence, on objections, on entering things into evidence. It's great to refresh yourself on that because in my firm, and when you have civil cases, you only try a couple cases a year. I'm not trying a case every week. I'm trying 2 or 3 cases a year. So there can be 3, 4, 5 months that go by between trials. So it's great to keep up and refreshed on the rules and how this always works. Vic and Wes, do you have to specialize as a lawyer? Example, medical malpractice. No, you can be a jack of all trades and do everything if you want. I just choose to specialize on injury cases and wrongful death cases, catastrophic injury, car accidents, negligent security cases. I focus on that because I want to dive in, learn, know, and master those rules in that type of case. That's what my dad did. My dad specialized in only did criminal defense, and I just think that's the best way to do it, in my opinion. I would want somebody that specializes, so that's why I do. Michelle Woods, I'm usually not into ASMR, but the sound of you sipping your water is fascinating. Interesting. I feel like I exaggerated at that time. DTC primetime. On appeal, is only evidence was published considered? Yes, or evidence that's proffered, meaning evidence you wanted to get in, the judge said no, and you proffered it and said, this is the evidence I would have put in if you would have let me put that in. That can also be used in appeal, but not some new evidence or picture that never even came up. Stacy Walpole, Rob/Law and Lumber and Trago Charity Golf Tournament info yet? No, but after just coming back from a golf trip, one could say I learned some things on how to put something on. So it has not been forgotten. I'll just say that. Kurt, do you golf if you're in the chat? Houston H4M Dog Street team. If they bring perjury charges in Australia, would Amber have to go there? Could she be extradited? I have no idea. I don't know that answer. But if they file charges and she just like ignores them and hopes they go away, I do think that stuff could come back if there is a future trial. All right. We're going to end with this here, Joe. Thank you. Thank you all. As always, this was fun. We're signing off here. Hope everybody enjoys the holiday that's here in America. Happy 4th to everybody. You all are the best, as always, literally the best YouTube viewers. Come on here, ask questions, are nice, respectful, even when we disagree. It's always fun. I see the last couple comments I'm going to get to, but I wanted to say thank you before I signed off. As always, that's how I like to end it. Amelia Thompson, I'm going to law school in Canada. I was wondering how you chose what field of law you want to practice. I love your channel. Keep up the fantastic work. So I actually was blessed with a bunch of different opportunities to try different things. Like I said, I did mock trial and moot court. So I was able to try cases in the employment law field and the medical malpractice case. I was also able to do moot court, and I was able to do something in the constitutional law realm and then another employment law realm. And then I clerked at a firm that did criminal defense, medical malpractice, nursing home negligence, and personal injury, which was basically everything I was interested in because I wanted to be a trial lawyer. I knew that. That's where I felt like I could use kind of what I was gifted at and what I felt like I had a calling towards. So I was able to get experience. That's what I would say. Get as much experience clerking, interning, trying to go watch cases and get invested and immersed in different areas of law and see what calls to you and what you feel most satisfied in and most fulfilled doing. And mine was fighting for injured victims. Mary Liebrecht, what can we expect to hear from the court on Amber, or when can we expect to hear from the court on Amber's motion? Figuring out how to ask questions, LOL. I don't know. The court can take its time in answering this. There's no real answer that they have to turn around that I'm aware of, unless this jurisdiction has different rules than we have here. But I don't think it's going to be, immediate. Peggy Wolf, I finally figured it out. Had to go to my MacBook. You look good on the big screen. Thank you. Yeah, a lot of people said you do have to do it on your computer and things like that. People said I missed 2 super chats. I apologize. I get to absolutely as many as I can. Asking you all in the gallery to think of vets when using fireworks for the 4th. PTSD is real. Yes, thank you to all of the vets. Oh no, my free membership super chat didn't get seen. Sorry if we missed your super chat, Tori. All right. You all are the best. I appreciate everybody that joined our live tonight. Until the next time, I'm out of here. See you next week.